Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann, and today we have a very special episode of the show. As part of our ongoing series covering the November 4th Louisiana elections, we're going to speak with two candidates for Domestic Section 1 of Civil District Court in New Orleans. Domestic Section 1 is a dedicated family court, and the winner of this race would oversee that section for the next term. Now, family law is obviously an area of the law that is very personal for so many people, and it almost certainly affects you or somebody close to you. That's why this race is so crucial, and why it's so important that the voters know all the facts before they make their decision. Bernadette D'Souza, the incumbent, has sat on the bench since 2012. Before that, she was a family law attorney and advocate against domestic violence for 20 years. Her challenger, Taetrece Harrison, has been a practicing family law attorney for nearly 10 years. Our goal today is to have a cordial, productive conversation that lets the voting public get to know the candidates, their ideas, and the issues a little better. Taetrece Harrison and Judge Bernadette D'Souza are with us on Power of Attorney. Thanks so much to both of you for joining us.
Thank you.
So let's get right into the questions. We're going to start with the incumbent. Judge D'Souza, how would you define the role of a judge, and what best qualifies you to be reelected for that position?
As a practicing lawyer, having dedicated my career to family law and domestic violence work in the community, I came prepared for this job. I was elected unopposed in 2012. I worked very hard in getting the family court seat at Civil District Court, having worked with the legislature because there was a desperate need for a family court for our city. I've come to the bench well prepared. I've been fair. I've handled thousands of matters, as a matter of fact, and I am looking forward to my re-election to continue the work that I started as a domestic court judge at CDC.
Okay. Now I'm going to pose the same question to you. Taetrece Harrison, how would you define the role of a judge in domestic court, and what best qualifies you for that position?
What defines a judge would be a fair judge, an impartial judge, a judge that would allow both parties to be heard, the opportunity for dads and moms to have some type of resolution when they come into court, which best qualifies me as I've been practicing law for almost 10 years in many different areas of law, and that qualifies me because most of the people that come into family court are looking for issues in many different areas. It's not just really based on child support or child custody. They have many different issues, personal issues and relationship issues, and I know that I can handle those issues. As a single mom, I've had to deal with many different issues, and also as a pro se litigant, I understand what issues the litigants are posing when they come into court.
Okay. Next question goes to Ms. Taetrece Harrison again, and it's a different question. How does this specific court, the domestic family court, differ from other courts?
Well, for domestic, you're dealing, I like to call it mom and dad, because you're dealing with mom and dad issues, or you're dealing with people that are getting divorced. So in a regular court, you're dealing with plaintiffs, so you're dealing with a money judgment, or people trying to seek a judgment for money. When domestic court, you're dealing solely with child support, child custody, domestic violence issues, as well as divorces, as well as partition of community property. So that's exclusively what you're going to be dealing with in that court.
Okay. Bernadette D'Souza, same question. How does this specific court, the domestic court, differ from other courts?
It differs greatly because it's a dedicated, exclusive, limited jurisdiction court. All the judge does there handles, just like Ms. Harrison mentioned, divorce, custody, child support, partitioning of community property. It's hurting families that are coming before this court. You have to have the knowledge, the experience, understand the dynamics of what that family is going through when they come before a judge. You listen to the cases, you hear the evidence, you apply the law, and you make the best decision in the interest of the children. That is the whole focus of that court. Yes, it's a good understanding of other issues that come before the court, but the judge in family court has no jurisdiction over those issues. You take that into consideration when making your decision.
Okay. next question goes to, well, I didn't get to ask you that same. No, next question is a new case, a new question. What is the most pressing issue facing family court today? And that's for Ms. Harrison.
What is the?
Oh, I'm sorry, Ms. D'Souza. We're going from individual to individual. We're not asking the same question. Ms. D'Souza, what is the most pressing issue facing family court today?
The most pressing issue is the pro se litigants that come before the court, the self-represented.
Pro se means someone who does not have an attorney
That's
representing
correct.
him or her.
That's correct. They're not able to afford a lawyer. And as a legal aid lawyer, having worked representing these very clients that I did come before this court, so I have a good understanding of what they're going through. I worked with the Louisiana State Bar Association through the Access to Justice to have a self-help desk. There are forms that are available. It's sort of a way to have an entree into the court to know what forms need to be filed for a divorce 102 or a divorce 103. So they have access to the courts filling the right forms.
And quickly, what's a divorce 102 or a divorce 103?
A divorce 102 is when you file a petition and live separate and apart for a period of 6 months or 365 days if you have children.
Spouse, one spouse living separate and apart from the other spouse.
That's
okay.
correct. And a 103 divorce is having lived separate and apart for a period of 6 months or 365 days. If you have minor children, then you can file a petition for divorce. And so they have to understand which petition to file. It sort of provides an access to the court system.
The self-help desk.
That's correct.
Okay. Now, Ms. Harrison, same question for you. What is the most pressing issue facing family court today?
I would say the most pressing issue is the pro se litigants, and it doesn't necessarily mean if you have experience that you have the wherewithal to understand those litigants that are the parties that are coming into court. I understand the litigants because I have been a pro se litigant. I represented myself in law school at my own divorce and had to seek my own child support. So I definitely can relate to those parties. Although I have not been practicing for 18 years, I still have the experience. I've been living a long time, so I've lived many different places, so I can relate to many different people on many different levels. I believe that the pro se litigants are not getting the necessary resources. The self-help desk is there, but it's not providing them with all the resources that they need, and that is coming from people that I've spoken to since I've been campaigning, that they don't feel like they're being heard, nor do they feel the resources are available to them, and that's coming from mothers and fathers that are coming into the courtroom. So I believe that the pro se litigants feel that there's a failure for the court to understand exactly what their needs are, and those needs are not being addressed.
Okay. Next question, and that's for you, Ms. Harrison. What do you think is the single most important thing a family court judge should determine?
The threshold out of everything that happens in that court is what's in the best interest of the child. In order to get to that, you have to work through the issues that the parties are coming to you into court, meaning that you have to hear those parties, not just shift the parties off to mediation without them being heard. If the parties are pro se litigants, which means that they cannot afford an attorney, and they've taken the time to spend money to finally get into court, why is it that if this seat is a dedicated seat that those parties then will have to spend more money to then go see an attorney? If those parties already could make the determination they needed to see a mediator, they could do that without the necessary requirement of the court's involvement. They can go see a mediator on their own. They don't need a judge to give them an order to go to mediation. So one of the things I think is that the parties, it needs to be in the best interest of the child, but you still have to get through what the parties' issues are in order to get to the best interest of the child.
Same question for you, Judge D'Souza. What do you think is the single most important thing a family court judge should determine?
The single most thing that a family court has to make a decision is what is in the best interest of the child. There are the 12 best interest factors that you have to weigh as to what parties come before you. There are a lot of hurting families that come before this court. There's so much contention, and mediation is a form of a national best practice that is done all over this country. Along with my colleagues at an en banc meeting, the Civil District Court judges decided to set up a pilot program. I have 2 other colleagues that are my domestic court judges right now that have the exclusive domestic docket, and we all 3 send cases to mediation where we believe that if the parties are so contentious, it gives them an opportunity to go before a mediator and air out their differences and their disagreements and come together in the best interest of that child and how to co-parent that child.
And just briefly, and I think you've kind of explained it a little bit, but just briefly, define what mediation is for those people, those viewers who might maybe aren't clear what mediation is.
Okay, there is a statute that we have that allows a judge to send parties to mediation, and mediation allows the parties, if they have disagreements, to come to an agreement in the interest of their children. They make the decision rather than a judge telling them, and this is mostly in contentious cases. The mediation program that has been implemented at CDC is just 3 sessions. The mediators give them an opportunity to come to the table. It's on a sliding scale. And
it means financially a sliding scale?
Financially is a sliding scale, depends on what their income is. And if after the 3 sessions they're not able to resolve their issues, then they come back to court. There's a court date that's already given to them prior to mediation. I've seen almost about 90 to 95% success rate.
In other words, they work out an agreement in the mediation.
That's correct.
But they're not forced to agree if they don't want to agree.
They're not forced to agree.
All right, Ms. Harrison, in fairness to you, I want you to be able to give your definition of mediation and to respond or give your viewpoint on mediation as much as you'd like.
I totally disagree with what my opponent just said, because of the fact that if the court is supposed to be a dedicated seat, that has been fought for this dedicated seat, and that, as we both have stated, that they're supposed to be hearing family law cases, then what would be the point? And then if initiating a mediation process, if you're there for a dedicated seat to hear the parties, then hear the parties. Don't then send them off somewhere else. It's a revolving door. And as far as the success rate, I disagree as far as the success rate, because the people I've talked to, which is the community, throughout the community of New Orleans, from the East Bank to the West Bank, are telling me that their issues are not being resolved, that they feel that they are going through a revolving door. There's a continuation of a continuation. And as far as the sliding fee scale, they still can't afford it, no matter what the sliding scale is. At $150 to $200 an hour, if these people are pro se litigants that can't afford attorneys, where are they supposed to find the money for a mediator?
May I respond very briefly as to the free service that is provided? When the program was implemented at Civil District Court, Southeast Louisiana Legal Services applied for a grant to the Louisiana Bar Foundation, and they had an attorney there that handled mediation without any costs to people that can't afford. And part of the program, the mediators are obligated to take 2 or 3 cases a year to help the poor people that can't afford mediation. It's really, the whole focus is for the parents to come to an understanding as to what is in the best interest of their children. When they make those choice decisions for their own kids, you see less of them in contentious and contemptuous situation in a family court.
We're going to have to take a break.
Okay.
This is a really great discussion, but we have to take a break. Coming up next, we'll continue our judicial forum with Judge Bernadette D'Souza and Taetrece Harrison. Welcome back to the show. We're continuing to talk with Judge Bernadette D'Souza and Taetrece Harrison, who are running for Judge of Domestic Section 1 of Civil District Court in New Orleans on November 4th. Let's get back to our questions. Next question, we'll start with Taetrece Harrison. What types of clients have you represented in your time as an attorney?
I've represented a lot of different clients, from criminal, tax clients before the IRS. Handle personal injury cases, family law cases, of course. Also, I've helped people with foreclosure cases where they've had their houses going into foreclosure. Bankruptcy clients. Also handled civil litigation where people have sued insurance companies. A little bit of DWIs as well, traffic matters. So I've handled a lot of different things.
Okay. Judge D'Souza, how about you in your private practice before being elected, or elected to the bench?
All right. After graduating from law school at Tulane, I decided to dedicate my career to public interest law. I worked at NOLAC, which is New Orleans, was the former, now is Southeast Louisiana Legal Services. And I started out doing housing law there. I represented a lot of public housing tenants against the Housing Authority of New Orleans. I did a lot of fair housing discrimination cases based on race, familial status at federal court. And eventually, when I got appointed at the YWCA, as a board member, I was the president of the board. I recognized a need for representation for domestic violence victims in civil courts. I became so passionate about that issue because my client, who I was representing at the Gretna Courthouse, was gunned down by her husband. It was a murder-suicide at that time. So I became a voice for the voiceless and did a lot of domestic violence work. I was appointed at Tulane Law School as an adjunct professor to teach domestic violence and the law, and as a result, you now have a domestic violence clinic where law students are getting the education to go out there and represent victims of abuse. I managed a family law unit with 6 lawyers.
Okay.
Yes.
All right, we got a lot of questions still to get to. All right, next question is for you. Please describe a situation in which you took a controversial position that angered or offended people, and explain how you handled it.
I don't think I ever encountered a controversial issue to be able to respond to that question. In terms of, you're asking me about
either
cases?
as a lawyer or a judge, where you took a position maybe that was politically or socially unpopular, but you did what you felt like you had to do, even if it upset people.
I think I have the judicial temperament in my courtroom, and if there are any moments where an attorney is unprofessional, I've had to kind of talk to the attorney to be respectful to each other. But when things get out of hand, as a judge, I can sanction a lawyer that's unprofessional in my courtroom. And so I've been able to do that with the right temperament, with the right amount of compassion for what is being brought before me.
Okay. For you, Ms. Harrison, same question. Please describe a situation in which you took a controversial position that angered or offended people, and explain how you handled it.
I would probably say that was when I represented a client that had 4 DWIs. That would definitely be controversial because of the fact that that person could endanger lives.
How did you handle that?
I handled it I did represent the person. I did discuss with him some issues, explaining to him that he probably needed to seek some type of counseling. He had lost his mom, as well as some other personal issues that was going on that was affecting him, and that's why he continued to drink and drive. We eventually, he had gotten 1 in New Orleans, and then he had gotten the other 3 in St. Tammany Parish. So I was able to facilitate some type of agreement in the St. Tammany Parish Court, and we were able to get him in some type of counseling.
Okay. Next question is for you, Ms. Harrison. What is your vision for the future of family court in New Orleans, and what changes would you advocate and why? What I envision is fairness, impartialness, resolution. Also that people don't feel that when they walk into the courtroom that they've already defeated before they have a chance to open their mouth, and that's moms and dads. Feeling that they're actually being heard. That's the #1 thing that people feel that is not occurring
when they go into court that they're not being heard. One of the things I would try to facilitate is some type of court-mandated counseling when you have parties that are getting divorced. When I sought my divorce in Texas, that's one of the things that they require is that the parties after the divorces, as you're going through the divorce process, that the two parties go to some type of counseling, and they also offer counseling for the children if they're of a certain age. And I would do that at a limited amount as far as cost, not an exorbitant amount.
Okay. Same question for you, Judge D'Souza. What is your vision for the future of family court in New Orleans, and what changes would you advocate and why?
Okay, I came to the bench with a vision to create a family court at Civil District Court, and it was very humbling for me to be elected as the first family court judge for our city. I have had such a wonderful opportunity setting up programs in the family court area. One, of course, is the Civil District Court mediation program. The self-help desk that I worked on, there is a possibility that we might have the pro bono project and volunteer lawyers providing some limited representation for parties that can't afford a lawyer. And the other thing is really connecting the resources to the families that come before me. Since I've been on so many nonprofit boards, very recently I was appointed by the mayor to the Total Community Action Board. So I am out there in the community, having served the community as a legal aid lawyer for my entire legal career. I have a great vision for this court to continue building the foundation I started as a family court judge.
Okay. Next question is for you, Judge D'Souza. Do judges have an obligation to improve the public understanding of the courts? If so, how should they carry out that obligation?
I think judges do have an obligation to get involved in the community. Very recently, I was appointed on the National Association of Women Judges as co-chair of the Domestic Violence Committee. And this is allowing judges to take on judicial leadership to confront societal problems. And so getting involved in various organizations, being out there in the community, particularly for family court judges, is to recognize what the needs are of the families that are coming before a family court judge and provide those resources that are needed.
Okay. Now, Ms. Harrison, same question for you. Do judges have an obligation to improve public understanding of the courts? And if so, how should they carry out that obligation?
Absolutely. The judges owe the public to have some understanding of what the courts are like, or what's available to them. And I believe that the way to do that is actually go to the people, not be a part of an organization. Being a part of an organization may limit certain people from having access to that because they may not be aware of that organization. So I would actually, just like I'm going in the community asking people for my vote, I would do the exact same thing once I'm on the bench and actually go back to those same people to let them know what is going on in the court, what I'm doing, and do the exact same thing, go out and reach and touch the people.
Okay. Next question is for you again, Ms. Harrison. What are your views on whether the court as a whole deals effectively with racial and gender bias?
I'm sorry, did you say that again?
Well, what are your views on whether the family court as a whole deals effectively with racial and gender bias?
I think that there is some biases there. From what I've gathered from campaigning, that dads feel that they don't get an opportunity to be heard. But on the same token, then moms feel like they're not being heard. They feel that the dads are not paying child support. The dads feel like they're paying too much child support. So there's definitely a breakdown somewhere in the courts not being able to effectively make both parties feel like they're being heard. And then as far as racial issues, most of the people that go into court are going to be of African American. You're not going to see, the percentage is probably a little bit higher as far as that. So again, those same biases will probably exist among those people because they're mostly the ones that go in that courtroom.
Okay. Judge D'Souza, same question. What are your views on whether the court as a whole deals effectively with racial and gender bias?
I think as a judge, you have to be unbiased and impartial. Those are our judicial canons. The litigants that come before me, I treat them fairly. I'm gender blind. As my opponent mentioned about child support issues, I have to make a decision whether there is going to be food on the table for the children, whether the fathers can pay to clothe their children. There is no such thing that the father has to pay a lot of money. There is the Louisiana child support guideline that has to be applied when making a decision as to what portion of the amount is child support. And so child support is essentially handled by the DA's office. You have the assistant district attorneys that come well prepared, and the ones that are represented by counsel submit those child support guidelines, and a decision is reached.
Now we're at the last question. And last question goes to you. It's your turn. You got about a minute to tell me, what would you like to tell the viewers about yourself that you haven't already been able to say, for them to consider when they make their decision in the poll booth as to whether or not to vote for you for this position?
Well, I have the experience, the knowledge of the law, the compassion, the work I have done in the community over 18 years. I have dedicated my legal career. I've worked in the trenches, so I understand the situation that the litigants come before me as a judge. In 2.5 years, I've handled over 5,000 matters in my courtroom. I've worked efficiently. I have gotten involved in all of those national organizations to bring back to the family court the national best practices, to set up a model court for our city and perhaps the best model court in the country.
Okay, thank you. Ms. Harrison, you get the last word. What are, tell us what you would like the viewers to know about you that you haven't already said as they make their decision on whom to vote for this important position.
I would like to say that I am from New Orleans, born and raised here, so I can definitely relate to all parties that are coming into this court. I offer 3 things. I'm a single mom. Most of the people coming into court are single moms. Most of the people coming in court are pro se litigants. I've been a pro se litigant. Most people who are coming to court are seeking child support. I've had to do that on my own. I could totally relate to every single person that's coming in there. Experience is great, but there's a lot more that you need than just experience. You need to be able to relate to these people in order to be effective. They want a judge that's fair, they want a judge that's unbiased, they want a judge that's going to be there on time, resolve their issues, and not feel that they're going through a revolving door.
Thank you very much, ladies. That's all the time we have. Excellent discussion. Well, there's so much more to cover, but unfortunately we're all out of time. We thank you both for joining us and doing the public a great service and letting them get to know you better before the big election in November. Remember, you can learn all about everything we talked about today on the show's website, johnredmannpoa.com. You can also learn where you need to go to vote. Watch every episode of the show and submit your legal questions that we'll try to get an answer on the air. Thanks again to our guests, and thank you for watching. We'll see you next time on John Redmann, Power of Attorney. Ladies.